Evolution of labor law. A little about the Edict of Turgot and its influence on labor law. The Edict of Turgot, promulgated in 1776 in France, was an important milestone in the history of labor and economics, with significant repercussions on the development of labor law. Although it did not create labor law itself, its provisions influenced the way work was organized and regulated, paving the way for future labor legislation. Main points of the Edict of Turgot. Freedom of labor. The edict abolished craft guilds, which were associations that controlled access to certain professions and limited freedom of labor. This measure aimed to promote free competition and economic development. Abolition of privileges. The edict also eliminated several privileges and regulations that restricted economic activity, such as monopolies and restrictions on trade. Defense of free enterprise. The Edict of Turgot defended free enterprise and economic freedom, principles that would become central to economic liberalism. Influence on labor law. Although the Edict of Turgot promoted freedom of labor, it also generated negative consequences for workers, such as lack of protection and exploitation. The lack of regulation led to precarious working conditions and the intensification of labor exploitation. Despite this, the edict contributed to the development of labor law by highlighting the need for labor regulation and protection of workers' rights. Criticism of the negative consequences of the edict drove the creation of labor laws that sought to balance economic freedom with social protection. The idea of freedom of labor, even if initially applied in an unregulated manner, was one of the starting points for the debate on workers' rights. In summary, the Edict of Turgot represented an important step in the transition to a market economy, but it also highlighted the need to protect workers' rights. Its influence on labor law lies mainly in having contributed to raising awareness of the importance of labor regulation and social protection. The Chapelier Act and its relationship with labor law. The Le Chapelier Act, enacted on June 14, 1791, during the French Revolution, had a profound impact on the development of labor law, although its original intention was not to regulate labor relations. Its main points and relationships with labor law are: Main points of the Le Chapelier Act. Prohibition of associations. The law prohibited the formation of any type of association or craft corporation, whether of employers or employees. This included unions, guilds and other forms of collective organization. Defense of individualism. The law was based on the principles of individualism and freedom of contract, arguing that labor relations should be negotiated individually between employers and employees, without the interference of collective organizations. Promotion of free competition. By prohibiting associations, the law aimed to promote free competition and prevent the creation of monopolies or privileges. Relationship with labor law. Obstacle to collective organization. The Le Chapelier law represented a major obstacle to the development of labor law, as it prevented workers from organizing into unions and other forms of collective representation. This made it difficult to fight for better working conditions and defend workers' rights. Lack of protection for workers. By defending individual freedom of contract, the law left workers in a vulnerable position, subject to exploitation and the imposition of precarious working conditions by employers. Influence on economic liberalism. The Le Chapelier Law reflected the principles of economic liberalism, which advocated non-intervention by the state in economic and social relations. This view influenced labor legislation in several countries during the 19th century, delaying the creation of laws to protect workers. Lasting impact. Although it was repealed in 1864, the Le Chapelier Act left a lasting legacy in labor law, highlighting the importance of collective organization and state intervention to ensure the protection of workers' rights. In short, the Le Chapelier Act, by prohibiting workers' associations, delayed the development of protective labor legislation, with the idea of individual contracts prevailing, where the employer, who owns the means of production, prevails over the employee. The Moral and Health Act, and its relationship with labor law. The Moral and Health Act of 1802, also known as the Health Act, the Morals and Health of Apprentices Act, was one of the first pieces of employment legislation in the United Kingdom, and marked an early milestone in the regulation of working conditions, particularly for children and apprentices. Key features of the Act. Focus on apprentices. The Act focused on apprentices, who were often children and young people working in factories and workshops. Working conditions. It set out minimum regulations for working conditions, including limiting the working day, requiring adequate ventilation and hygiene, providing adequate clothing and accommodation. Basic instruction. The Act also required apprentices to receive basic instruction in reading, writing and arithmetic. Supervision. It provided for the appointment of inspectors to ensure compliance with the Act. Relationship to employment law. The Morals and Health Act is considered a precursor to modern employment law. It recognized the need to protect workers, especially the most vulnerable, from exploitation. The Act established the principle that the state has a role to play in regulating working conditions, marking a shift away from the idea of unrestricted freedom of contract. Although limited in scope and application, the Act paved the way for future labor legislation that would address issues such as working hours, safety and health in the workplace. The Act also highlighted the growing concern about the effects of the Industrial Revolution on the health and well-being of workers, driving the development of public policies in this area. In short, the Moral and Health Act represented an important early step in the evolution of labor law, demonstrating the growing awareness of the need to protect workers and regulate working conditions. The 9 general principles relating to the organization of work that were elaborated during the Treaty of Versailles. The Treaty of Versailles, signed in 1919, not only ended the First World War, but also laid the foundation for the International Labour Organization, ILO, and formulated 9 general principles relating to the organization of work. These principles have been crucial to the development of labor law on a global scale. Here are the 9 principles. 1. Principle of equality. Men and women should receive equal pay for work of equal value. 2. Principle of freedom of association. Both employers and workers have the right to form associations to protect their interests. 3. Principle of living wages. All workers should receive a wage that allows them to have a reasonable standard of living. 4. Principle of the 8-hour working day. The working day should be limited to 8 hours per day and 48 hours per week. 5. Principle of weekly rest. All workers have the right to a weekly rest period of at least 24 consecutive hours. 6. Principle of protection of children. The exploitation of child labor should be abolished. 7. Principle of equal treatment for foreign workers. Foreign workers should receive the same treatment as national workers. 8. Principle of labor inspection. Governments should establish a system of labor inspection to ensure compliance with labor laws. 9. Principle of international cooperation. Countries should cooperate to improve working conditions worldwide. These principles reflect the concerns of the time for social justice and the need to protect workers from exploitation. They influenced labor laws in many countries and remain relevant today. The meaning of mandatory norms in law. In law, mandatory norms are rules that cannot be changed or ignored by the parties involved in a situation. Think of them as mandatory laws that apply to everyone, regardless of what people want or agree to. In simpler terms, mandatory. These are rules that must be followed, without exception. Non-negotiable. People cannot make agreements to ignore or change them. Public interest. Generally, they protect important interests of society, such as fundamental rights or public order. Examples: laws that prohibit discrimination. Rules that guarantee safety at work. Rules that establish the minimum age to vote. Difference to dispositive norms. There are also dispositive norms, which are more flexible. They can be changed or left aside if the parties involved agree. They generally serve to fill gaps in agreements or contracts. In short, mandatory norms are the hard rules of law, which ensure that certain principles and rights are respected by everyone. Juris et de jure is a Latin expression used in the law to refer to an absolute presumption, that is, something that the law considers to be true and that does not admit proof to the contrary. In simpler terms, presumption. It is a conclusion that is drawn from a fact, considering it to be true. Absolute. Oh, it means that this conclusion is definitive and cannot be contested. Juris et de jure. Oh, it indicates that this presumption is established by law and is considered unquestionable. Example: in some cases, the law may presume that a person is guilty of a crime if certain conditions are met. This presumption, juris et de jure, means that it will not be allowed to present evidence to try to prove that the person is innocent. Difference to juris tantum. There is also the expression juris tantum, which refers to a relative presumption. Oh, in this case, the law considers something to be true, but allows evidence to be presented to contest this presumption. A simple explanation for juris et de jure in the field of law. In short, juris et de jure is a legal presumption that cannot be refuted, while juris tantum is a presumption that can be challenged with evidence. The meaning of the expression jus resistentiae in the field of law. In simple terms, jus resistentiae means the right to resist. In law, this expression refers to the possibility of an individual or group to oppose an order or action that they consider unjust or illegal. In other words, it is the ability to say no to something that violates their rights or principles. It can manifest itself in many ways, from refusing to comply with an order to participating in protests or strikes. In the context of labor law, for example, jus resistentiae can manifest itself when a worker refuses to perform a task that puts their safety at risk. Important points. Jus resistentiae is not an absolute right. It is generally subject to limits and conditions, which vary according to the legislation of each country. Resistance must be proportional to the injustice or illegality that is intended to be combated. In many cases, jus resistentiae is related to the defense of fundamental rights, such as freedom of expression, human dignity and the right to a fair trial. In short, jus resistentiae is the tool that allows individuals to defend themselves against abuses of power and defend their rights. Labor law is a legal system permeated by institutes, values, rules and principles aimed at subordinate and similar workers, employers, associated companies, service providers, to protect the minimum employment contract, obligations arising from labor relations, measures aimed at protecting the working society, always guided by constitutional principles, mainly that of human dignity. It is also full of rules aimed at unions and representative associations, to the mitigation and form of resolution of individual, collective and diffuse conflicts existing between capital and labor, to the stabilization of the social economy, to the improvement of the social condition of all those involved. Characteristics. Autonomous law, a special law, a mandatory standard, public order law, irrevocable right, autonomy of labor law. What identifies the autonomy of a branch of law is the fact that it presents particular principles, e.g., principle of protection, primacy of reality, etc., its own legal categories, e.g., unions, collective agreement, collective convention, normative sentence, etc., having special and specific sources, having its own methods, rules, that is, using special procedures to know the truths that are the object of its investigations. Sources of labor law. Material sources. Its pre-legal moment of the norm, that is, it is not yet positive. Political, social and economic facts. X. Strike. Formal sources. Corresponds to the legal norm already established and enacted. Formal sources can be autonomous, drawn up by the parties. X. Agreement, collective agreement, custom. Heteronomous, drawn up by a third party. X. Law, normative sentence. Conflicts of formal sources. Norm most favorable to the employee. If there are several valid norms applicable to the same legal relationship, the most beneficial norm must be applied. The prevalence of the most beneficial norm will depend on the sources that are in conflict. Law X law. The most beneficial norm prevails according to the theory of mitigated conglobation. Collective agreement X collective convention. Principles of labor law. Principles are types of values considered relevant to society, such as justice, freedom, peace, human dignity, etc. Although they are not always explicit in the law or in the constitutional text, the principles have normative force and have the function of substantiating the law, interpreting the law and assist in its application. Labor law principle. Protection. Unavailability of labor rights. Primacy of reality. Imperativeness of labor standard. Continuity of the employment relationship. Unchangeable contractual harm. Irreducible salary. Principle of protection. Prescribes the need to opt for the standard and condition most favorable to the worker. It is based on the idea that the worker is the weaker party in the employment relationship, the underprivileged party, and, therefore, deserves protection. Therefore, the purpose of this principle is to correct inequalities, as well as to substantiate the imperativeness of labor standards, which means, in theory, that the parties, when entering into an employment contract, could not set them aside. It can be broken down into three: in dubio pro trabalhe or in dubio pro misero, interpretation of standards. In cases of doubt, the legal operator must apply the standard most favorable to the employee. X. Prior notice. Application of the rule most favorable to the employee. Conflict of rules. If there are several rules applicable to the same employment relationship, the one most favorable to the employee must be applied. Application of the most beneficial condition to the employee. Working conditions. The advantages already obtained cannot be withdrawn, much less changed for the worse. Principle of primacy of reality. Prevents formal documents from prevailing over the reality of the facts. Principle of continuity of the employment relationship. As a rule, employment contracts are signed for an indefinite period. Fixed-term contracts are exceptions. This principle aims to preserve the employment contract, ensuring social stability. Notes. Principle of irrevocability or unavailability of labor rules. As a rule, the employee is not allowed to waive or negotiate labor rights. Expanding the possibility of agreements between employee and employer. X. Vacations. Principle of unalterability, intangibility, of a contract that is harmful to the employee. Amendments to a contract are lawful if they are made by mutual consent, employee agreement, and, even so, as long as they do not result, directly or indirectly, in harm to the employee, under penalty of nullity of the amendment. Beneficial amendments are valid and permitted. Principle of intangibility, irreducibility of wages. Wages cannot be reduced, except by collective agreement or convention. Labor standards in time and space. within the territory. Labor law legislation must regulate all employment relationships that arise in the national territory, as it is enforced throughout the country and as federal law. Work relationship and employment relationship concept. The worker is an intermediary of the union to provide services to different recipients, without personal contact, on a rotation basis. Casual workers are not employees, but they are guaranteed all the rights of workers with employment contracts. Types of casual workers. Door worker works near the seashore, lake or river, that is, in the port sector. Casual workers can be registered or registered. Registered workers have priority in the distribution of work, while registered workers only work when the number of registered workers is insufficient to meet the demand for the service, observing the necessary rotation. The remuneration and definition of functions and composition of the terms, as well as other working conditions, must be included in the collective agreement, the result of a prior negotiation, carried out between the entity representing casual workers and port operators, but must be observed. Non-port worker is a casual worker who works for several contractors, without an employment contract, necessarily intermediated by the union of the category. They can perform their services in the port area or not. X. Sheet metal workers, provide services in loading and unloading cargo, without regularity or repetition. All non-port casual workers, but only those who work in the movement of goods. The union will be responsible for registering and recording casual workers, in a document separate from the membership card, to avoid giving preference to union members or inducing union membership. The union will be responsible for distributing the workers, on a rotational basis, under equal conditions. The contracting party, in turn, will be responsible for directly collecting the social and tax charges of the casual worker, as well as for paying the union the remuneration of those workers, to whom they are jointly liable, up to the limit of the use of casual work intermediated by the union. Characteristics of casual workers. Freedom in providing services, since there is no employment relationship with the union, much less with the companies contracting the services. It is possible to provide services to more than one company, as is the case in practice. The union or labor management body acts as an intermediary for the labor force, placing workers where the service is needed, subsequently charging a fee for the services provided. Already including labor rights and social security and tax charges and dividing the amount between the people who participated in the provision of the service. Short period in which the service is provided to the beneficiary.